appeal in the matter of the Queen on the application of Mungur and the Secretary of State for the Home Department.
Yes.
My lady, my lords, I appear on behalf of the appellant. My learned friend, Zain Malik QC, appears on behalf of the respondent. Just a few housekeeping matters.
We had received your speaking note. Thank you very much indeed.
Briefly, my lady, and it should be a trial bundle and an authorities bundle with 8 tabs, but I've added one case, the case of Lumber, for tab 9. Oh, only because, just an abundance of caution is why I added that one. I know it's quite long, but it's only one paragraph I'm referring to, really.
Well, that's very reassuring.
Mr. Babu, let me just confess that Lumber is my least favourite case in the entire canon of authority.
Some 345 paragraphs, I know, it's quite lengthy, but I just wanted to avoid something that occurred. But I think my learned friend agreed this morning that maybe the main case of Hock might not be relevant to this appeal, but I'll get into that as I go along.
Right. Well,
I'm afraid I haven't got... Yes, I have. Sorry.
Now, this is a judicial review of decision from the Secretary of State of the 20th of September 2019. And if I can just take you to that decision, it's on page 92, well, 91 of the bundle. I take you to page 92, the immigration history. You can see the very first arrow. You entered the UK on the 5th of October 2001 with entry clearance as a student valid until the 25th of September 2001 to the 25th of September 2003. If you go to page 93, looking at the last 4 paragraphs, you can see consideration has been given to your immigration history. And because they're taking it from the 5th of October 2001 till July 2011, they seem to believe he has 9 years, 9 months he's acquired of continuous lawful residence, and therefore he does not meet paragraph 276B1A. Further, they indicate you have overstayed your leave to remain in the UK in breach of the immigration laws by 1,947 days, and therefore he's unable to demonstrate you meet the paragraph 276B Roman numeral 5. Now, on that basis, the appellant served the pre-action protocol letter, which is on page 96 to 98. This is on the 18th of November 2019. And what we look at is at page 97 is the key point made in that the solicitors draw to the respondent's attention that the client entered the UK as a visitor on the 16th of April 2001 with entry clearance until the 22nd of September 2001. But he left on the 1st of September and then returned with entry clearance as a student on the 25th, which was granted on the 25th, but he returned on the 5th of October. You turn the page over, it's asserted that he has a continuous residence with no break, and therefore he satisfies 276B as an entitled to indefinite leave to remain. Now, in response, we have at page 100 to 103, the Secretary of State, and if you look at page 102, under the highlighted portions, the Secretary of State views your client entered as a visitor and left the UK before his visit visa expired on the 22nd of September. As your client was granted a visa for 6 months or less as a visitor, this visa would have lapsed when he left the UK regardless of any further visa. Therefore, he has not lived in the UK continuously from the 16th of April 2001.
You may begin to deal with this later.
Yes.
But it is, and this is as much for Mr. Malik as you, but if someone has a visitor's visa allowing for multiple entries,
Yes.
does it lapse when they leave the United Kingdom?
No, it doesn't.
That's
correct, my lord, yes.
So that is an error, that reference to lapsing. Yeah. Good. Thank you.
Now, the appellant at that stage issued judicial review proceedings, and this is at page 77 to 80. And if you look at page 79, I think at paragraph 4, he basically repeats what he said in the pre-action protocol letter and makes strict reference to the policy, which is just above in italics, which clearly indicates if the appellant has existing leave to remain and they left and returned to the UK, the existing leave does not have to be in the same category. On departure and return, for example, an applicant can leave the UK as a Tier 4 general student and return with leave as a spouse of a settled person. If we now turn to the acknowledgement of service, which is on page 65 to 69, the key page is page 68. Paragraph 6, this is where the respondent first makes the submission under 276A, Roman numeral 3, indicating that the immigration rule states continuous residence is considered to have been broken if the appellant left the United Kingdom in circumstances in which he could have no reasonable expectation at the time of leaving that he could lawfully be able to return. As the applicant was only on a visit visa and left the country on the 1st of September without any other form of leave, the respondent submits that it's clear that he had no reasonable expectation, ... Therefore, his continuous residence was broken on the 1st of September 2001. So that was the basis of the judicial review. Now, the decision by the upper tribunal is on page 44. And if you look at paragraph 3, you can see the judge has taken the view the end date is not challenged in the grounds. The grounds contend that the period of continuous lawful residence began on the 16th of April 2001. However, the fact is that the applicant entered the United Kingdom on the 16th of April 2001 with a visit visa valid until the 22nd of September. Accordingly, the respondent was unarguably entitled to conclude that when the applicant left the United Kingdom on the 1st of September, he had no reasonable expectation he would lawfully be able to return to the United Kingdom. And therefore, paragraph 276A, Roman numeral 3, applied. At paragraph 5, the court held that the grounds are hopeless and totally without merit. At page 29, we have the skeleton argument because the appellant appealed to the Court of Appeal. His skeleton argument, if we look at page 29 in his submissions, I would say the penultimate paragraph, 1, 2, 3, 4, 5, 6, 7, 8, 9 lines up, he again reiterates what he's saying in the PAP, in his grounds of appeal, in the statement of facts before the judicial review. And he relies extensively on the published policy. Now again, this policy is 28th of October 2019. This was after the decision of the 20th of September, but the previous policy is the same, which is what the policy I'm relying on today. But it's the same content.
And you've set out the relevant bit of the relevant policy in your speaking note.
Yes, I have.
Thank you.
My lord, yes. Page 60, the Court of Appeal looked at the application and asked for further submissions. This is at page 60. The court expressed some reservation as to the approach to visitors' leave, but then asked for further submission based on the case of Hock. And that statement from the respondent is on page 48 to 51. But if I take you to page 49, you can see at the bottom of the italics of paragraph 4, the Secretary of State's position is The appellant's original entry clearance was for a temporary purpose, namely a visit to the United Kingdom.
I'm sorry, the fault is mine. Can you just give me that reference?
On page 49,
Yeah, I got that.
paragraph 4,
Yep.
at the bottom of the italics of that paragraph, it starts with the sentence, the
Yes,
appellant.
thank you very much.
The appellant's original entry clearance was for a temporary purpose, namely a visit to the United Kingdom. As a visitor, he was only allowed to reside in the United Kingdom for a maximum of 6 months and had to leave by the expiry of his entry clearance. He obtained that entry after satisfying the entry clearance officer that his intention was to return to Mauritius after a short visit to the United Kingdom. He had no reasonable expectation of return to the United Kingdom after the 22nd of September 2001 without obtaining a fresh entry clearance. And then at paragraph 5, he adds, the Secretary of State adds for the first time, there's a further more serious difficulty in that he cannot satisfy paragraph 276b, Roman numeral 5. And if we turn to page 50 over, the Secretary of State actually recounts the leave that was as an overstayer after the 13th of July 2011 up to the 10th of February 2016.
Is it that's common ground? That's the relevant date, is it? Because that was when the application was made. Is that right, Mr. Malik?
Yes, ma'am.
Yeah.
So on that point forward, he had leave under Article 8, but on a different basis, nothing to do with long residence. And he made a subsequent application which was granted under not long residence, but again Article 8. So that's the position as we are.
And that means that when this application was made, you weren't an overstayer at that time.
Well, the Secretary of State
You weren't a
accepts.
current overstayer
Well,
because you had leave at the time. At the time you made this application
yes,
for ILR,
yes.
you were a person who currently had leave. Yes, I think that's common ground.
It's common ground, but I mean, I've looked at the papers myself, and
And you're not sure.
there's a slight delay, I would say. His leave ended on the 8th of May 2019. His application, however, was made. Bear with me.
I thought you squeaked in. 30th of May.
30th of
So
May.
it's made 22 days after.
22 days, yes.
But that is not, the Secretary of State is not
Hasn't taken issue with
treating you as a current overstayer.
overstayer. No, they have not.
That's right, Mr.
That's the same.
Yes. Yeah.
Now, as those are the issues, if I refer you to my speaking note, I do have set them out at paragraph 1, A and B, first and second. And now I'm going to take you to the immigration rules and policy. I'll ask for your patience. I may do it in a haphazard way.
Well, if you're going to work through the immigration rules,
Yes.
you will have the patience and sympathy of the court.
Yeah, I was just trying to make my submissions make sense, or hopefully make sense, but I'll do it in a way which you could see the point I'm trying to make. If for any reason it doesn't, please let me know. So if we look at tab 1, and we look specifically at page 204 of that, we see paragraph 276b, 1a. And that's the focus at this stage. It says, he has had at least 10 years continuous lawful residence in the United Kingdom. And this deserves some unpacking and explanation.
Can I ask, I have to say, I don't think I would normally consider somebody who is here on holiday as being a resident. But is there any authority about that? I mean, I don't know whether residence includes presence, or whether it's a narrower concept, or whether it's for the parties to, you know, whether there's no ruling about it and it's up for grabs.
My Lord, I wouldn't say there's a ruling to my knowledge, but I think the rules itself does take it into account, which is what I wanted to take you to next.
All right.
Because
Can we just clarify with Mr. Malik, because you took us to page 49.
Yes.
Yeah.
in paragraph 4, where the respondent refers to the appellant as residing.
Yes.
So at the moment, unless I've misunderstood it, I don't understand the respondent's objection to be that the period of presence with the visitor's visa was not residence for the purposes of continuous lawful residence.
The
Is
word
that-
residence is used 3 times in paragraph 4 to describe the nature of the visitor's occupation.
Yes, that is correct. The lawful residence phase is defined in the rules as someone having existing leave to enter or remain.
Ah, that's the answer. So
Yes.
any kind of lawful presence is residence. Is that right?
Yes,
Can you
tab,
just give the we may be going to the section.
this is paragraph 276, capital A, small b.
At
Right.
page 202 of the in that bundle.
So I'll-
202.
Yes, so not only that residence, but if someone has temporary admission, even that counts as lawful residence.
Right.
So-
Okay. Thank you.
Can I just get
But
this
that-
absolutely clear? On page 202, we've got the definition of lawful residence at B, yes?
Yes,
And then where do you say visitor comes in there? On existing leave to
Yes.
enter or remain?
absolutely. Yes.
That's it, is
Yes.
it? That's
But
it.
it's circular. That this is, I mean, I'm not inviting you to resile from your position, but just to try and understand it, it is circular because lawful residence means residence,
Yeah.
which is residence pursuant to existing leave or to enter or remain. And I think my Lord's question was, if you're only here as a visitor, are
Yes.
you resident? But anyway, that's not a point that the Secretary of State's taking.
No, not in this way. No.
Thank you.
So I was going to take you to 202, which is lawful residence, and focusing on Roman numeral 1, which is existing leave to remain. And if I ask you to turn to tab 3, and we look at page 21 of tab 3. This is paragraph 6 of the immigration rules. It sets out the definitions and interpretations of terms. At page 21, you can see visitor, which is the third from the bottom, and it highlights a person is granted leave to enter or remain in the United Kingdom. And if you turn back to tab 1 and page 201, you have the definition for continuous residence. It means residence in the United Kingdom for an unbroken period, and for those purposes, a period shall not be considered to have been broken when an applicant is absent from the United Kingdom for a period of 6 months or less at any one time, provided the applicant in question had existing leave to remain or enter upon their departure and return. And finally, if I take you to the policy on tab 2, and we look at page 10 of 43, you can see after the heading time spent outside the UK, we have 3 bullet points, and then the paragraph at the bottom. as to what is considered not broken. And the paragraph that was highlighted in the skeleton argument and the statement of grounds, that you can leave in one category and come back in another, once you have valid leave when you left and valid leave on your return. Now, with that in mind, if we go to the Respondent skeleton argument, which is at page 38.
Page
38 of the bundle.
38, thank you.
At the top of paragraph 22. I think the primary focus for the Secretary of State, and again he'll correct me if I'm wrong, is that the appellant's original entry clearance was for a temporary purpose, namely a visit to the United Kingdom. As a visitor, he was only allowed to reside in the United Kingdom for a maximum of 6 months and had to leave by the expiry of his entry clearance. If you go ... down to the last paragraph, the position might have been different if the original entry clearance was also as a student. The temporary nature of the residence as a visitor means that it falls to be excluded under paragraph 276A, Roman numeral 3 of the immigration rules. At the bottom of paragraph 23, 1, 2, 3, 4, 5, I think 5 lines from the bottom, it starts, visitors are allowed to enter the United Kingdom on a temporary basis, and only if their intention is to leave the United Kingdom after a short visit, they are not allowed to remain in the United Kingdom in excess of 6 months. In this context, it is inconceivable that the Secretary of State, in formulating 276A, Roman numeral 3, would have intended for an outcome whereby a person is able to include his residence pursuant to a visit visa in the calculation of 10 years residence to obtain indefinite leave to remain. Now, the short submissions being made against this is this. It appears that the objection is twofold. One, it's temporary in nature, and two, maybe the limit, because it's mentioned in 6 months leave only, and you don't have in excess of 6 months. I think for the appellant, it's just trying to determine where is this in the rules or policy. If the Secretary of State wanted temporary in nature, all leave is temporary, save for settlement. If you're here as a student, you're here on a work permit, you're here on Tier 5 Minister of Religion, it's all temporary. And you all have to leave, you have to leave at the end of your visit. So it's the same as a visit visa.
It's temporary in the sense that it's not permanent, but isn't there a qualitative difference between a visitor's visa and someone who will typically be longer term, for example, a student or a work permit holder?
Well, I'm not seeing what the difference actually would be. I mean, if we're looking at visitors, and it's defined as existing leave to remain or being granted leave to remain. Lawful residence, very first heading, existing leave to remain. So it matches what's said in the, actually said in the rules. There's no distinction, there's nothing, there's no exclusions, there's no exceptions to say does not include visitors, does not include leave less than 6 months. There's no qualification for it. Nothing's mentioned about it other than the Secretary of State making the assertion. If you look at the policy, you look at the rules, then if somebody's been granted leave to enter or leave to remain, then there's no reason why it doesn't qualify.
It may be that it's not really for you, but rather for Mr. Malik to deal with this. But can you give any indication of why you think the rules have the concept of no reasonable expectation to return? What purpose does that serve?
Well, I was coming to that because looking at the rule itself, after that, if you look at the rule, and if I take you to that very briefly, I think I have it in my speaking note, set out actually. I think if you look at paragraph 11, I have the rule.
Yeah.
And a short submission on it, in that the rule, as I see it, is twofold. It's not just no reasonable expectation at the time of leaving. It adds in that he would lawfully be able to return. It's not just no reasonable expectation, but also lawfully be able to return.
Well, no, that's the nature of the expectation.
Yes, because at certain times your leave can be, you can overstay or breach a condition. And in that context, you may not lawfully be able to return because you have to wait a certain amount of time because of that circumstance. But in this, there's no reason, just because it's temporary in nature, that you have no reasonable expectation to return. Because as a student, you're given leave for a certain time, either for your course, a year, 2 years, or 3 years. After that leave, and you leave the United Kingdom, if it was just it's temporary in nature, then there's no reasonable expectation a student will come back. It's the same premise. There's no difference between it. If a student leaves at the end of his grant of leave, why would the Secretary of State expect a student to return but not a visitor? Bearing in mind you leave when your leave was intact, not after it's ended.
But that goes straight to the root of it, doesn't it? Because the grounds say that he left the United Kingdom to make an application.
Yes.
So if we take that for the purposes of the argument, he returns after his student visa has
been granted.
His student visa has been granted, but after his visitor visa.
Yes.
Is there any guidance of which you are aware, either in authority or in the rules, as to what is capable of giving a reasonable expectation? Because by definition, on the date he left, he knew he could come back the next day as a visitor.
Yes.
He knew he could come back up till the 22nd of September as a visitor.
Yes.
But he did not know whether an application to be a student would be accepted, rejected, or anything like that. So at the moment, I'm completely unclear as to where the expectation is targeted, whether it's targeted at the moment he leaves, at the moment, or the existence of current entry clearance, or at the date when he actually comes back. And I've not seen in either of your helpful submissions anything which helps us on that.
Well, I think the position of the appellant is that because there's no difference between as a visitor, so he had leave as a visitor until the 25th of September 2001. He leaves on the 1st of September, and he must have applied during that time because he's granted leave as a student on the 25th
his leave
of
as
September.
a visitor expired on the 22nd, didn't it?
Yeah, the 22nd, yes, sorry. Yes, the 22nd, but he was granted leave as a student on the 25th, that's 3 days later. So at some point he's applied before his leave has ended. Now, for us as the appellant, because the Secretary of State's focus is that our leave is temporary in nature, and therefore by itself means we have no reasonable expectation to return. However, they accept if we were a student before we left, that would be okay. But as a student, if your leave is for a certain period to study a course, whether it be a degree or otherwise, it ends at that point. When you leave, there's no expectation you can come back as a student, or you're willing to come back as a student, or as a spouse. You would not know until you apply and it's granted. So the same circumstance applies as a visitor. There's absolutely no difference. Because the question you've asked me, my lord, is, well, how would you know your application will be granted? How do you know? And I think that would be for anybody leaving after your leave is ended. You don't know if you could come back as a student or as a spouse.
But it's a question which goes one deeper than that,
Yes.
which is what is capable of giving someone a reasonable expectation, and to what is the reasonable expectation targeted?
My lord, I think the first question is obviously if you leave and you have existing leave, so you've maintained your conditions, you've leave before your grant has ended. So there's no basis why any application should be refused if you meet the relevant criteria of the immigration rules. Because the only way you could automatically be refused is if there's a general grounds of refusal, which is why it's lawful. So if you have maintained your leave as you're supposed to, you have not breached any conditions, you've not overstayed, then if you apply for any application and you meet the criteria, there's no reason for it not to be granted. I think that applies across the board.
You say, that, is this right? You say that you will have a reasonable expectation if you prima facie comply with the rules.
Yes.
Unless, I take this from what you said earlier,
Yes.
unless you've in some way infringed the rules
Yes.
before you left, such that you wouldn't expect to be allowed back in.
Yes, my lord.
That's basically your concept.
Yes, my lord.
So, does it come down to this, that at the time of leaving, although it's not said in the grounds or
Yes.
anything, he had a reasonable expectation of being able to lawfully return because, as events have shown, he qualified for a student visa.
Yes, and he didn't do anything that would jeopardize that
Yes.
application being granted. Yes.
He hadn't, by his conduct during the existing leave, jeopardized his future prospects.
Yes.
And your submission is simply the fact that he got the student visa means that in a highly regulated system for applying,
Yes.
he had a reasonable expectation that he was going to succeed.
Yes, but I think the point I'd like to more reinforce is that I think the Secretary of State's view is that because a visitor's visa is temporary, that is enough. And that means because it's a temporary nature, that's enough for the assumption that there's no reasonable expectation to return. I think that's the way the case has been put, that this is a temporary visa, temporary in nature, it was just a visit, and it's a maximum of 6 months. Therefore, on that basis alone, there's no reasonable expectation to return. And I think that can't be right.
Well, I don't understand that, because if it is the case that someone can return
Yes.
on a different basis
Yes.
and still provide continuous residence, not be outside 6 months, I just don't see the basis then for that argument.
Yes, ma'am, because even their policy says you leave as a student, come back as a spouse,
That's
or
what
you
I
can
was
leave as a spouse and
no,
come back as a
that's what I
student.
was referring to.
Yeah, so this is why our submission is based on that point, that the very submission doesn't meet the policy or the rule.
And I think underlying it
Yes.
is the sense that being here as a visitor is qualitatively different, as my lord says, than being here in another capacity.
Well,
but for myself,
yes.
if one accepts they're all residents, which I'm
Yes.
very doubtful about, I have to say,
Yes.
but on the basis that they are all residents, I'm not sure whether the rules allow any distinction.
Well, because
So that's in your favour.
I think I'm grateful for that, my lord, because I think when I look at the rules as they are, because they are difficult, but I'm looking at it as it's drafted. The very first heading for lawful residence is existing leave to remain. And the very definition of the very definition of visitors is being granted existing leave to remain or leave to enter. That's the definition of it. So you clearly meet the first criteria of lawful residence. And then for continuous,
Sorry, where's it gone?
if you have left in one category, you could come back in another, and which is what was done.
And you want to argue this in your JR?
It was, I think, put forward in the jail, but I think it wasn't really accepted as a point.
No, but that is your case.
That is the case for that point, absolutely.
On issue 1.
On issue 1, yes. Unless I have any other questions on it, I can move on to issue 2.
Jeremy?
No, thanks.
Thank you.
For issue 2, this is where, if I make a small correction, if you look at paragraph 17, the first sentence is without leave from the 13th of July 2011, not 2013. And we do accept that we were or without leave during that period.
I mean, I wonder if we can shorten this bit.
Yes.
You say that the proper interpretation of hoc is that you don't count, that these periods of overleave, as it were, earlier, after 10 years,
Yes.
but before the current situation, simply don't come into the picture.
Yes.
Right. I mean, I think provisionally that's our view, having read the
Right.
case.
Okay. Yeah.
So I
yeah,
wonder
no,
if we
that-
can hear what Miss. I mean,
Yeah, I think, and I've referred to their policy, which the policy reinforces that once you have it, you could come back on a lawful basis. And that's why I had Lumber.
Yes.
Well,
Because
that's right.
Lumber said you follow the...
Well, if we can avoid reading
Yep.
Lumber, that's fine.
you're a bookend case.
Yes,
aren't
yes.
you? And
Yes.
You're a bookend case, and if you've got your 10 years, which
Yes.
is issue 1,
Yes,
then you're not a current overstare, which
Yes.
would be elements A and B of hoc.
yes, yes, my lord. That's our short point
That's
on
it.
That
that.
is your short point.
That's our short point on that,
Yes.
yes, absolutely.
Okay.
Right. Right then, let's hear from Simone.
Lady, my lords, may I take you respectfully to tab 1 of the authorities bundle, where you have the relevant rules.
Sorry, where are we looking?
This is tab 1 of the authorities
Yes,
bundle,
yes.
the very first page. So you have seen paragraph 276A of the immigration rules. It defines continuous residence, and you'll see that it means residence for an unbroken period. And milady and milords will see that in 3 circumstances, a residence shall not be considered to have been broken. First, where the absence was less than 6 months. Secondly, where an applicant had existing leave at the time of the departure. And thirdly, where the applicant has existing leave at the time of their return.
So which one do you say applies? Or doesn't?
Well, in this particular case, these 3 conditions were met at the relevant time. But the submission, milady, milords, is that that where these 3 conditions are not met, it is clear that the residence would not be continuous residence. So if one follows that, milady, milords, it will become apparent that what are listed as conditions 1 to 5 provide further limitations to the concept of continuous residence. So in other words, before you get to Roman 1 to Roman 5, you are already a person who left the UK with existing leave to enter, came back with a leave to enter, and your absence was less than 6 months. So there must be a purpose, in my respectful submission, behind Roman 1 to Roman 5.
So you're saying they're effectively that they're an exception
To the exception.
to the 3 lines above, which is A, B, and C that you've just given us.
Absolutely.
6 months
in-
leave to on departures.
In other words, exception to an exception.
Yeah.
So the fact that a person left the UK with existing leave and returned with a fresh leave would not be considered as continuous residence if any of the subparagraphs in Roman 1 to 5 apply. If you then look at Roman 1 to 5, and you will see that 1 concerns a person who has been deported, 2 concerns a person who left with an intention not to return, 3 is the relevant provision, but C4, a person who has committed a criminal offence, and 5, a person who has been absent for more than 18 months.
So that's aggregating. So if during the period in question
Yes.
he has periods out which are not individually 6 months or more, but in aggregate are 18 months,
Yes.
then he's out.
Yes.
Can I ask, I'm sorry, I know it's not directly relevant, but what does paragraph 2, what's it aimed at, as it were? Has evidence to clear intention not to return? It might be said every visitor visits and leaves. I mean, what? I'm not really clear what that's getting at.
A person who, for instance, a student who completes the course of study and then informs the Secretary of State that he has decided to leave the United Kingdom to settle elsewhere, for instance, but then return after a short period of time in a different category.
But in practice, they wouldn't tell the Secretary of State, would they? I mean, that can't mean that, surely.
No, but there are certain circumstances where, in at least in my experience, an applicant would sign a disclaimer saying that he is leaving the United Kingdom to obtain a different sort of benefit. For example, if someone is in detention and says that he wants to leave the United Kingdom voluntarily, the Secretary of State may speed things up and let that person leave the country.
But in reality, evidence, which is what 2 speaks about, is likely to have to be documentary evidence, isn't it? I mean, it doesn't matter for today's case, but it's not good enough to walk through Heathrow saying, I'm never coming back.
Yeah. For example, there is a particular category in the immigration rules that require an intention to return. There is an issue about whether that requirement is met. An in-country application is made for further leave to remain. The applicant says that, well, I only need further leave to remain for another 3 months, and then I'm going to leave for good. He then leaves the country and then comes back on a different category. The Secretary of State will then show.
But that would be documented. That would be documented. And the example you've given would be documented.
Yes. But my submission is that the court must construe subparagraph 3 in a way that makes sense, and that gives that paragraph some meaning. If you accept the argument that my learned friend has made, in my respectful submission, subparagraph 3 would lose its purpose. It's difficult to see in what circumstances subparagraph 3 would apply if it does not apply in these circumstances. As my Lord pointed out when my learned friend was making his submissions, that a person who is leaving the United Kingdom, on a literal reading of this rule, can always have an expectation of return, because whether a person is here as a visitor or as a student, he can always leave the country, make a fresh application, and then return.
Does a student application such as for this appellant have to be made out of country?
No. No. So a student is entitled to apply within the United Kingdom for further leave to remain.
But can a visitor apply while in the United Kingdom?
No.
No?
No.
So he had to go back to Mauritius in order to do so?
Yes.
So the statement in the grounds that he returned to make an application is not implausible?
It's not. No. It's not. Yes. It wasn't an option for the applicant to apply in country for further leave to remain as a student.
But the question, what constitutes reasonable expectation, can't depend upon whether he intends to reapply or not, or does reapply or not. It's got to be, even if he doesn't reapply, somebody at that time might say they have a reasonable expectation if what? On your case, what does it mean on your case?
Well, my short submission is that the phrase lawfully be able to return, properly construed, means lawfully be able to return on his temporary leave.
Well, he would have been able to. He could have done that at any time until the 23rd of September.
Lord, with respect, that is not correct. So, if a person, may I just identify the difference between leave to enter as a visitor and leave to enter in a different category, for instance, as a student, because my learned friend argued that there isn't a material difference. And if I identify 4 differences, then that may answer the point that is troubling my Lord. So first, a visitor must demonstrate an intention to return after a short visit, and in any event, within 6 months. So if you don't demonstrate that intention, you won't get entry clearance as a visitor. Secondly, once you are in the United Kingdom, you must leave after a short visit and in any event within 6 months. Third, further extension in your entry clearance as a visitor is not possible. And fourth, Milady, my lords, if you...
Sorry, on your third one, does that mean you have to go and make a fresh application for a fresh visitor's visa?
Yes.
You can't simply apply to extend your visa?
No. And you cannot switch into any other category as well.
And you can't make a fresh application while you're in the country.
Yes.
So you've got to leave.
You've got to leave, yes. So that's the difference. So if you come here as a student, you don't demonstrate an intention that you will leave. You are here on temporary basis, but it's open to you to get further leave to remain, apply from within the United Kingdom for further leave to remain, and ultimately if you reside here continuously lawfully for 10 years, you get indefinite leave to remain. And fourthly, if you just had a holiday, you would not, if you just had a holiday for 5 months, then you won't have an expectation to return for another holiday within days. So when Lord Justice Stuart-Smith asks that, well, the appellant could have re-entered the United Kingdom immediately after his departure, the answer, my lords, my ladies, is that if he had arrived back, in all likelihood, he would have been refused entry on the basis that he just had his holiday for 5 months. And
What's the point of giving him multiple entry then?
well, the multiple entry visa, my lord, enables a person to have multiple holidays in the United Kingdom without obtaining visitor's visa every time he applies. So if a person comes to the UK for a short holiday, resides here for a week, returns to his country where he stays for 5 months, and then comes back for a week, that is permissible.
And if he comes here from
But
the
if he-
16th of April to the 1st of September, goes to Paris for a couple of weeks, comes back on the 17th of September, okay?
Well, if a person has already spent 5 months in the UK on a holiday, and if he then leaves the country and seek to return within days, then in all likelihood that the Secretary of State would say that that person is not a visitor because he just had the holiday for which he was given entry clearance.
It sounds pretty arbitrary to me.
Well, let's take a case of someone, say, who comes from Africa,
Yes.
and they're flying to London, and they've got a plane that goes out 6 months later, so they're just within the rules, the 6-month limit for a visitor, and they go to Paris after 5 months, and they come back to London for a few days before getting the plane. Isn't that something they could lawfully do?
Well, I mean, of course, the Secretary of State, even in that context, can say legitimately in my submission that the applicant had just had his holiday for 5 months. So what is the purpose of returning to the UK after staying here for 5 months? So if
They catch a plane back home,
well,
in my example.
well my lord, can be a situation I accept where the point wouldn't arise, but it would, in my respectful submission, at least enables the Secretary of State to take the point that there isn't a reasonable expectation to return if a person has already spent 5 months in the UK as a visitor.
So now what I'm grappling with is if the reasonable expectation is as confined as you say it is within the concept of the visitor's visa, why then do you have in the policy, tab 2, page 10 of 43, the fact that someone can leave the UK and return in a different capacity and it still constitutes continuous residence?
Because that's what 276A small a says, that if a person leaves the country with limited leave to enter and returns with fresh entry clearance, even if it is in a different category that that person would qualify. But the policy does not say that if a person comes to the United Kingdom as a visitor and then leaves the United Kingdom and comes back in a different category, that would count as continuous residence.
If a person who has just been on a holiday or is on a holiday, but leave the holiday out of it. Let's go to the more basic question.
Yes.
If a person satisfies the criteria for a student license and applies for one, a student visa and applies for one, do they not have a reasonable expectation that it will be granted?
Yes, they'll have a reasonable expectation that
So
they'll be able to return lawfully
So leave aside the fact that he was here on a student
on a visitor's
visa. All we know is that he did satisfy the criteria for a student visa.
Yes.
And there's nothing to suggest that his ability to satisfy the criteria changed between the 1st of September and the 25th of September or whatever it was.
No.
So why can it not be said of him that he has a reasonable expectation? He's going back to Mauritius in order to make his out-of-country application. He has a reasonable expectation that it will be granted and he'll be able to come back.
Lord, because if you adopt that construction, then that would apply to every case, because when a person leaves the United Kingdom, there's no indication as to what application he would make, whether he would satisfy the requirements of the rules or not. He can always argue that there is a reasonable expectation that he would be able to return.
A reasonable expectation is subjective. He doesn't have to tell the Secretary of State as he goes through Heathrow, by the way, I'm going to make an application and I'm going to be a very good student.
That's correct, my lord. But that would apply, as I submitted respectfully, to every case, and that would mean that this provision becomes meaningless, and that brings me back to the point that I made earlier, that if this provision does not apply in these circumstances, in what circumstances it would ever apply?
Forgive me for interrupting you, but that surely brings into sharp focus your concession, which I'm not doubting, that the period spent here as a visitor is residence for the purposes of continuous residence. Once you accept that, where's the difference?
Well, Lord, that I have accepted, given the way in which 276A subparagraph B is expressed, and the Secretary of State accepts that leave to enter as a visitor is existing leave to enter pursuant to Roman 1. But it could not have been the Secretary of State's intention that for that reason alone, a visitor, residence as a visitor would qualify for continuous residence for the rule in question. So the concession that I have made, of course, is made on the premise that visitors' leave is otherwise excluded under Roman 3.
I'm still having difficulty as to why, if it's all residents, why somebody who has a student visa and then wants a marriage visa or whatever it's called, why they might have a reasonable expectation because they apparently satisfy the criteria for a marriage visa, let us say, why that is any different from somebody who had a visitor's visa and says, and now I believe that I'm going to qualify, because I appear to qualify, for a student visa. And I haven't done anything which should lead the Secretary of State to exclude me.
Well, there is I accept no difference. And that is why I have placed my emphasis not on the words reasonable expectation, but on lawfully be able to return on the temporary leave.
But sorry, I have to press you because I don't fully understand that. There are 2 points here. One perhaps is easier to deal with than the other. Talking about lawfully to return. Sorry, let me get the exact language again. I've lost it now. Lawfully be able to return. The first point is that if you have a visitor's visa, then I think you accept that you might often reasonably expect to be able to return. If you've got a visa for up to 6 months, you might have good reason to expect the Secretary of State will let you back in
Yes.
that 6-month period.
Yes.
But it seems to me that it's doubtful that this means that. I would have thought it meant that you had a reasonable expectation to return in the new capacity in which you're now relying. In other words, if you go from a visa, it doesn't mean that you expect to be allowed back in next week. But when you do come back under another form of permission, you have a reasonable expectation to be permitted to come back under that form of permission. But assuming that is the case, then I don't see why one isn't just focusing on, do you have a reasonable expectation? If you have a reasonable expectation to return, then whether it's as a student, whether it's as a marriage visa or whatever other form of visa there are, I really don't see how you can avoid that applying across the board.
Well, Lord.
Sorry, I haven't put that very well, but
Yes.
I'm trying to.
No, I understand. I understand the point, and I must accept that accords with how subparagraph 3 is expressed. But I do ask Milady and Milords to consider that if that literal interpretation is adopted, when will a person not have reasonable expectation to return? Never in my respectful submission on that reading, because at the point of departure, an applicant will always have an expectation that if he or she makes a fresh application for leave to remain under a different category, he would be able to return lawfully to the United Kingdom.
Well, I think Mr. Baruch would say, yes, that follows, unless he or she has blotted his copybook while they were here. In other words, would say, well, if that's what it means, that's what it means. And normally, somebody who's come here, I mean, one can strip away somebody who's come here. This is why I find this whole concept so difficult. I mean, anyone who hasn't come here might apply for a student visa and might have a reasonable expectation that they get the student visa if they satisfy the requirements, etc. They're not guaranteed, but they might have a reasonable. So it doesn't depend on them coming as a visitor. It just depends on this analysis of whether they appear to comply with the requirements. And so coming here as a visitor only enters into the picture if they blotted their copybook while they were here, so as to render it more difficult for them. But I can't really understand why this requirement is there in the first place. I mean, that's part of the problem.
Well, my submission is that it is there for this purpose, so to exclude a person like the appellant, who as part of his 10 years residence seeks to rely on residence as a visitor. I mean, take the example of a person who is given an entry clearance as a visitor for 6 months or 2 years. He comes to the United Kingdom for 5 months, leaves the country, then returns, stays here for another 5 months, then returns and accrues 10 years residence in the United Kingdom. So on Miller and Friends' interpretation, that person would qualify for indefinite leave to remain if all other requirements are met. Although his intention always was not to settle in the United Kingdom, was to visit the United Kingdom on a temporary basis, and to return to his or her country after a short visit. So that in my submission would simply defeat the logic and the purpose of the rule.
It's a very convoluted way of saying visitors are an exception.
Well, I'm afraid, Lord, it is. And of course, Lady and Lords are familiar with what the Supreme Court said in Mahad as to the construction of the immigration rules. This paragraph 10, I've referred it in my skeleton, that well, the rules are statements of the Secretary of State's administrative policy, and they must be construed in a way that makes sense.
I'm all for that, however difficult.
Yes.
And I also accept that A, we should probably not encourage further amendments to the rules.
Yeah.
And B, saying that someone could have said something clearly is normally a fairly poor aid to construction. But there is, I think it is right, isn't it? There is nothing in the rules or in the policy guidance which either says or necessarily implies that visitors are an exception when it comes to applying 276A.
There isn't a lot. There isn't.
And it would
Unless
be
they're
very
not
easy.
residing, but you're not taking that point.
Unless, my lord?
Unless they're not residing.
Yes, but that a person who has limited leave to remain as a visitor has limited leave to enter or remain. The Secretary accepts that, has accepted it.
I'm sorry, yes. Look, I'm not trying to push you to take a point you don't want to take, but it may be relevant in other cases.
Yes.
I don't see why the fact you've got leave to remain, I mean, I'm interested if there's some statutory provision or something, but I don't see why the fact you're given leave to remain means that you're given leave to reside, as opposed to given leave to enter and remain. I mean, you can remain, you remain here if you've got permission to be here. Within the terms of the permission.
I mean, there is some case law on the subject which suggests that even if you don't have existing leave to enter or remain, if you come to the United Kingdom illegally, for example, and you're given temporary admission just to allow you to stay here pending a bail hearing or an appeal hearing, even that counts as lawful residence for the purpose of this provision.
Well, I'd be interested to see see how one interprets that.
Yes, but I mean, I'm happy to provide you that authority, but that relates to subparagraph B2. You'll see this is page 202 behind tab 1. So lawful residence means
that's a specific.
Yes. So I'm not. Yes. So that authority, the authority that I had in mind, concerns that provision. But I'm not aware of any authority or any policy that suggests that a visitor is excluded from B1. But it is excluded in my respectful submission under 276A small a Roman 3.
Yeah. If we take the example of somebody going from student to marriage visa, there's still a requirement to comply with Roman 3. Yes, if somebody comes under a student visa and then makes an application for a marriage visa, and he's gone home and then made the application, let's say,
Yes.
He still has to have a reasonable expectation at the time of leaving that he would be lawfully be able to return. Is that right?
That's right. Yes.
Yeah.
Yes.
And how would you say you test whether he has that reasonable expectation?
Well, because there's simply no way in my respectful submission for the Secretary of State to say that there isn't a reasonable expectation that person would be able to return, because that person would always be able to make an application return, and that's my
a
point.
floodgates argument. Means that the Secretary of State would be admitting more people than she wants to, but it doesn't answer the question: what is or can be the foundation for a reasonable expectation? Because at the moment, I have no idea what the Secretary of State's position is on that.
My Lord, I do ask my Lord and my Lady to consider this, that if one follows this example, and I do apologize for repeating myself, then this subparagraph would become meaningless altogether. A person will always have a reasonable expectation to return in a different category or in the same category, on a literal reading of the rules. So the only way this provision can make sense is to read the words lawfully be able to return, as meaning lawfully be able to return on his temporary leave.
Well, then possibly someone should have written it.
Absolutely, I accept that I'm asking.
You accepted when my Lord Sir Patrick Elias was putting an interpretation to you that it was the literal interpretation based on the words.
I accept that entirely, and I also accept that I'm asking the court to read words in the rules that are not there. But that, in my respectful submission, is necessary to give some meaning to this provision. If the court declines to read these words in the rules, then in my respectful submission, the provision becomes entirely meaningless. A person would always have an expectation to return lawfully, irrespective of what that person has done.
Anything more on?
Finally, if the court, so another benefit in my respective submission of adopting this interpretation is that it brings some clarity to this rule, which is already a difficult rule that is difficult to follow.
I think we can agree on that.
Yeah. So this is a provision that has been criticized by this court on a number of different occasions. But that's what the rule says, and in my respective submission, reading these words for the reasons I've given is justified.
Mr. Malik, you are doing a valiant job in reading into this rule words that simply are not there.
But this is what, I mean, I'll come to Hawke in a minute, but this is what this court did in Hawke. The literal reading of the rule in Hawke did not make sense, and the court acknowledged that it was doing violence to the words of the rule, but said that, well, that violence was justified to give the rule in issue some meaning.
But
So
it's
it's not-
arguable. But it's arguable. I mean, the difficulty we have is this is an appeal against a refusal of permission.
Yes.
So essentially, we have to put in our we have to answer the question: is this reasonably arguable? The normal JR test.
Yes. Yes. Well, if Lady Malords, you're minded to consider simply the issue of arguability, then I can see why.
Well, we're not going to.
Malord would
Well,
say.
I'm speaking entirely for myself. I'm not going to volunteer to give the absolutely ultimate definitive reading judgment on what sub-paragraph Roman numeral 3 applies.
Yes, and in those circumstances, I can see why Malord would take the view that it's arguable.
Is that the closest we're going to get to a concession on this one, Mr. Malik?
Yes.
On the arguability test?
Yeah, you have heard my submissions.
I'm sorry, I'm going to ask you one more time
Yes.
about a particular point, if I may. I want you to compare two cases. One is somebody who's been here lawfully as on a visitor's visa and returns. He meets somebody, he falls in love, they want to get married. He goes home, he applies for a marriage visa. The other is someone who's come as a student. He stays here as a student, he meets somebody, he falls in love, he goes back and he applies for a marriage visa. Now, why do you say in the first case, in the case of the student, the case of the visitor, he would not have a reasonable expectation that he would lawfully be allowed to return, and in the case of the student, he would have a reasonable expectation that he would lawfully be allowed to return, when everything else is the same except for that one factor? How does that fit in any way to the language of this subsection?
Well, it does not. I must accept fit in within within the language of this provision.
I mean, you're really saying, doesn't it come down to this?
Yes.
You're really saying it could not have been intended that time spent here as a visitor should count towards the period of 10 years. Is that fair? Is that that's the substance of your case?
Well, I'll put my submission in this way, that if a person is here as a visitor, then he would not have, and has spent 5 months in the UK, then he would not have reasonable expectation that he would be able to lawfully
But you've
return
not
to the
told me
United Kingdom
why.
on his temporary leave.
You've not told me why his expectation should be any different from that of the student, save that he is a visitor, and that being a visitor disqualifies him in some sense from having that reasonable expectation.
Well, because that is in my submission the only way to give this.
But why?
Subparagraph
Why are you
some
wanting to say that? I'm putting it to you that the real reason you want to say that is that you think it must be clear that somebody who's here as a visitor shouldn't be allowed to count time spent here as a visitor as part of the 10 years. Isn't that underpinning the whole thing?
Well,
It may be a sensible position. I'm sorry, I'm not trying to say.
no, it is. But I do anticipate my Lord's next question, that if
Well, answer them both.
that if that is the case, then why I have conceded what I conceded earlier, that leave as a visitor actually counts as lawful residence for the purpose of subparagraph B. But that my Lord, I accept is the underlying reason why the Secretary of State is seeking to make this point. She has accepted that leave to enter as a visitor counts as lawful residence under subparagraph B, but she wants to exclude a visitor from counting leave as a visitor in the 10-year qualifying period, and that is the reason why the argument is being advanced in the way that I'm seeking to advance.
All right, let's go to the next one.
Yes. Milady and Lords have expressed a sort of tentative view that you have the point, and very short submission that I make is that if you look at the language of subparagraph 5, you'll see that it this is the last page behind tab 1. You'll see that it refers to in breach of immigration laws. What is clear in my respectful submission is that the words in breach of immigration laws apply not only to present overstaying, but also to past overstaying.
How can you run that now in the light of Hock? You might be right if the Supreme Court overtook, but the Court of Appeal position is clear now, isn't it, by a majority? And we're bound by that.
Yeah. Of course, Milady and Lords have read Hock. That was a case where the applicants had limited leave to remain. They accrued, say, 9 years in the UK. They then overstay and apply for indefinite leave to remain. It was common ground before the court that the past overstaying provides an exception to the requirement in subparagraph 1.
But that related to establishing the 10 years, didn't it?
Yes, but there was no concession by the Secretary of State in that case, or in my respectful submission, the judgment by this court that if there is a period of overstaying of more than 28 days or 18 days, or 14 days, that is not excluded, then that would be disregarded for the purpose of subparagraph 5 altogether.
Well, I think that's exactly what Lord Justice Underhill said, didn't he? You know, if you look from paras 31 to 34.
May I ask Milady and Lords respectfully to...
sorry, I'm not trying to catch up. This is an important point. If there's a genuine point of we can distinguish hoc, then we need to know what it is. Because
Yes.
for the moment, I don't see it. Because it's element C we're focusing on, isn't it? And element C has been held not to apply to paragraph 5, as I read it.
Isn't it also, doesn't Lord Justice Underhill make it completely clear in paragraph 41, where he says after the citation from Masoom Ahmed, as I have already said, the requirement is framed in the present tense, must not be in the UK in breach of immigration laws in the first disregard for current overstaying.
Just very briefly, if I may set out the Secretary of State's position, if I may ask the court to look at paragraph 20 first. So you will see that the court there identified 4 essential elements of the cases that were before it. And my lords and my lady will see that the present case does not fit in within the paradigm case that is identified there.
That's true, but the principle is what, the question is what principle has the court laid down
Yes.
in order to construe it?
So the court was considering the issue in an entirely different context, and so that's paragraph 20. And if you then go to paragraph 42 of the judgment, you'll see that there Lord Sandhill recorded the common ground that element C must be treated as qualifying the requirement in subparagraph 1A.
Yes.
The Secretary of State accepted that if in a book ended overstaying case, the gap is less than 28 days, then that would qualify the requirement in subparagraph 1. So if this applicant within the 10 years residence had a gap of less than 28 days, then this applicant would have qualified. And the conclusion is at paragraph 52. And what is said at paragraph 52 in my submission is the ratio of this case, which is that element B does not qualify subparagraph 1A.
Mm-hmm.
So that is the ratio of this case. This case, in my submission, is not the authority for the proposition that if a person completes 10 years in the UK and then overstays for more than 28 days or 14 days, that person would qualify for indefinite leave to remain.
Well, I don't see how address, for example, para 41, and tell me how that can be right. The whole tenor of this is you can't look at what Lord Justice Underhill called Part C, which is the part you're relying on, when you look at paragraph 5. Of course, I understand your point.
Yes.
That if you're right on the first point, so there's not 10 years,
Yes.
then you're okay on this too. Because, in other words, it all turns on the first point. But if you're wrong on the first point, then I don't see how this can help you. Do you accept that?
Well, the Secretary of State's position is that there isn't the requirement in subparagraph 5 is not met.
But Mr. You can't hide behind the Secretary of State. You've got to make a submission which has a rationale and a logical basis.
Yes.
If you're relying upon some logical reason for distinguishing Lord Justice Underhill and Lord Justice Dingman's judgment, then let's hear it.
Yeah.
If you're just saying the Secretary of State is arguing that for reasons which are not clear, that this doesn't apply, but we don't know why it doesn't apply to this case.
I was seeking to identify the reasons, namely that if you look at paragraph 20 of the judgment, you'll see that the court there was dealing with a different factual context. There was a common ground as to the relevance of element C to subparagraph 1a, and the ratio of the judgment is in paragraph 52, which is that element B does not qualify Roman 1.
But even if it's obiter, which I think is what you're saying, so
Yeah.
far as this case is concerned, it must be arguable for the appellant, isn't it? It must be arguable, and it's desirable that it should be argued. I don't want to encourage the appellant too much, but it's desirable it should be, because if there is a distinction to be made, it should be made by a court that's addressed it full on, rather than on an application for permission to bring JR proceedings.
I see the point, my lord. But my submission, respectfully, is that this authority, paragraphs 40, even if one looks at paragraphs 40 and 41, they do not say that one has to simply move element C to 1a, and then element C simply disappears from subparagraph 5 altogether.
That's exactly what they do say, though. But Ms. Mellor, can I see if I understand the position? If we were to allow the appeal and give permission,
I'm sorry, sorry if I'm... I thought permission has been granted, as I understand it. We're just determining the appeal.
to bring the appeal, yes. But what we're being asked to do is to overturn Judge Gill's refusal of permission to bring JR proceedings, isn't it? That's what I've understood the position.
Yes.
So that if we the consequences of us allowing the appeal would be that we would give permission to bring JR proceedings.
Yes.
And if I'm right about that, I think your position is that you would hope that in any judgment we gave, A, we wouldn't reach final conclusions, and B, we would record the Secretary of State's position.
Well, can we phrase?
Am I wrong
Sorry,
about this?
yeah, I'm a bit unhappy about that. Can we
Right.
raise it?
Yes, certainly. We're
Sorry.
going to rise for a moment.
All right.
Okay, I'm just going to show you the toilet. And then if you go through, and then when you go out, you'd meet the corridor. Go straight across, and you see toilets on the left. So where the other side of the courtroom. So when you go out, where the stairs are, you go straight across. Okay? Like that. Thank you for this. Thank you.
Court rise. Court rise.
Mr. Balrog, Mr. Malik, given the depth of the submissions that have been made and indeed the interaction with the court, it seems to the court the reasonable way forward on this is to go beyond the permission stage and to evaluate this as the full appeal. And in those circumstances, in the first instance, Mr. Malik, is there anything more, and take it in your own time as you want to do it, that you want to say on the first ground, and then you can deal obviously with the second ground. But I don't want anyone to be under any illusions. This is the full appeal.
Yes. I'm very grateful for that. I wonder if it's possible at all for the court to allow me just a couple of minutes to have a word
Do you
with
want
my...
us to rise?
Yes, for 5 minutes if it's,
Yes, of
if it's
course.
possible at all.
Yes.
Court rise.
Thank you.
Court rise.
Yes, Mr. Manick.
Milady, my lords, I'm very, very grateful for the opportunity. Well, I have taken instructions, in particular in the light of the observations that my lord Sir Patrick Elias made about the second point, namely the point about subparagraph 5. Having taken instructions, I would respectfully seek to abandon that point altogether. So if the court is with the appellant on his ground of appeal, namely the construction of paragraph 276A, small a, Roman 3, then given that the court is now considering the matter substantively, the court can proceed to simply quash the Secretary of State's decision on that basis.
Helpful. Thank you.
I'm very grateful. So, Lady, my lords, you have I think you have all the submissions that I wanted to make on the appellant's ground of appeal. I haven't taken the court to Mahad, but I suspect that the court is familiar with the authority. May I ask the court to consider paragraph 10 in particular?
Well,
That's Lord
look,
Brown. Sorry.
Yes.
Mr. Manick, this is the substantive appeal. If there's anything more you want to take us to, or anything more you want to say, you do it.
I'm very grateful. So in that case, may I take the court to tab 7 of the authorities bundle? And if I may ask the court to go to paragraph 10. So this is where Lord Brown identified the proper approach to the construction of the immigration rules. And if you look at the quotation, you'll see there's a reference to Lord Hoffman's judgment MO Nigeria. So when it comes to the question of the rules, then it depends not simply on the language of the rule, but also against the background and considering the immigration rules as a whole and the function that they serve in the administration of immigration policy. So if a literal reading of a rule is inconsistent with the immigration rules read as a whole, or is inconsistent with the context of the provision, then that construction, in my respectful submission, ought to be avoided. Now, if you then look at the next page, this is page 55 of the report, the text that appears immediately after the quotation. You'll see that when it comes to the construction of the rules, then the rules should not be construed with all the strictness that is applicable to construction of a statute or a statutory instrument, but sensibly. This is just between letter B and C at page 55. So the rules must be construed in a way that makes sense, and there should be a recognition that they are statements of the administrative policy, not the law of the land as such. And if you look at the next part of that paragraph, this is between letters C and D. You'll see that the real question when it comes to the construction of the rules is what the Secretary of State intended, because the rules are her rules. So that is the approach that Milady and Milords will apply when reading paragraph 276A of the immigration rules. Now, if you then go to tab 6 of the authorities bundle, the court is of course familiar with the authority. Hoc have already abandoned the point about haq, but may I make this point, that if you look at paragraph 8 of the judgment, where Lady Milords have the relevant rule, you'll see what subparagraph A, 1A says, has had at least 10 years continuous lawful residence, and that's it. And then you'll see what appears at subparagraph 5 on the next page. What the court did, and I think it's uncontroversial, is that the court effectively transported the concluding part of subparagraph 5 to subparagraph 1. That was inconsistent, the court acknowledged, with the natural and ordinary meaning of the words used, because an ordinary and natural meaning of the word used would demonstrate that if a person had no 10 years continuous lawful residence, then that person would not meet requirement 1, irrespective of any gap in the residence. But the court took the view that the violence to the language of the rules, adopting the phrase that Lord Sandhill used, was justified in order to give some meaning to the concluding part of subparagraph 5. So that with respect is the approach that I invite the court to take when reading the rule that is in issue here. So just taking the court back to tab 1 of the bundle, where you have the relevant rules. And just to emphasize that the 5 subparagraphs apply where a person had existing leave at the point of departure and at the point of return. And their obvious purpose is to provide a further exception, a further limitation to what appears in the opening part of subparagraph A. So if one follows that point, in my respectful submission, there has to be a purpose behind these 4 subparagraphs. And the only way, in my respectful submission, to give some purpose to subparagraph 3 is to confine it in the way that I have respectfully proposed. If the court concludes that subparagraph 3 is not confined in that way, that provision, in my respectful submission, will lose its purpose altogether, because any person who leaves the United Kingdom with existing leave to remain will always have an expectation, can always have an expectation to return in the same or a different category.
Unless he blotted his copybook. Do you accept that?
Unless he
blotted his copybook, unless he did something while he was here, which caused him to think he wouldn't be let back in.
No, there are two answers to that concern. The first is that even if someone has done something wrong,
yes,
that person can still have a reasonable expectation to be able to lawfully return in the UK, to the UK. I mean, for example, if a person in the UK has worked in breach of his immigration conditions, the entry clearance, it's open to the entry clearance officer to disregard that breach, grant entry clearance if there is a proper explanation for that. So the intention behind the rule could not have been, in my respectful submission, that it applies simply in the circumstances where there is a question mark as to a person's character or what he has done in the UK. Secondly, and more importantly, there is a different rule that addresses issues like that, and that provision appears at page 204. If you look at paragraph 276b, so this is the actual substantive rule. And
which page you on?
This is page 204, internal pagination, behind tab 1. So this is the actual substantive rule 276b. So the court, of course, is familiar knows about the requirement in 1A about 10 years continuous lawful residence, but see Roman 2. So even where a person has 10 years continuous lawful residence, the Secretary of State can refuse the application if there are public interest reasons as to why it would be undesirable for him to be given indefinite leave to remain. So if he has done something wrong, the applicant will be refused by reference to this provision. And subparagraph 3 of 276A
I'm sorry, Doctor, I don't want to.
Would not add anything.
This all gets rather arcane, I think. But no, I'm sorry. The point I was about to make was a bad one. But we're still puzzled about. Well, I'm still puzzled about exactly. And what you're saying is, effectively, in any case where somebody has a visitor's visa, they will be excluded from relying upon that to build up their 10 years.
That is.
You're saying paragraph 3 achieves that objective.
That is the submission. Yes, and the answer to the point that is troubling my lord is that if a person has done something wrong, then 276B subparagraph 2 is the rule that addresses that concern. Not only that, if you look at Roman 3 at page 204, there is another additional requirement. The applicant does not fall for refusal under the general grounds for refusal. Now those general grounds of refusal fall in a different part of the immigration rules, and there is a catalogue of reasons why a person would fall for refusal. They include a person who has worked in breach of his immigration conditions, for instance, has used deception, and so on and so forth. So if given that there are two provisions in 276B that expressly deal with the concern that Lord Sir Patrick Elias has in mind, that would not have been the objective in 276A small a Roman 3.
Yeah.
Sorry, have you finished that point?
Yes.
Can I take you back? You said otherwise a person with leave would always have a reasonable expectation. And in that context, were you thinking of the person who has visitor's leave but leaves early in the period, so they have remaining permission to come back during that period? Because what's the position for the visitor who leaves on the last day of his leave? So he doesn't have an expectation of being able to come back as a visitor under his current, and at that point he doesn't have his student visa, let us say.
Yes.
And you are submitting that person has no reasonable expectation of a student visa, or of having lawful grounds for returning. What's the difference? I know this is a question you've been asked in a number of different ways.
Yes.
But what is the difference between the visitor who leaves on the last day and the student who, let us say, has finished one course of study, who leaves on the last day of his student leave and without having applied yet for a further student visa?
Well, a student who leaves, do apologize. I should have been more clear, but
I'm sure it's my fault.
I'm sure the court appreciates that this is the rule which is not the clearest of the rules in this provision. So if a student leaves on the last day of his leave, then that student can have a reasonable expectation to return on a different category or in the same category. I accept that. What is different in relation to a visitor is that visitors are only allowed to enter the UK if they demonstrate an intention to visit the UK for a short holiday and then return to their country, further extension from within the United Kingdom is not an option at all. If they reside in this country for 5 months, then return to their country and seek to return the next day, they cannot have a reasonable expectation that they would be able to return on that limited leave without obtaining further leave to remain. So what I'm asking the court respectfully to consider doing is to read the words lawfully be able to return so to mean lawfully be able to return on his temporary leave. So in other words, if a visitor stays here for 5 months, leaves the country, then he won't have a reasonable expectation of return within a few days thereafter. But a student in that position may have a reasonable expectation, because a student is not subject to the same conditions and limitations as a visitor. A student is not required, for instance, to have an intention to leave the UK after a short visit. A student is allowed to stay for more than 5 months. A student is allowed to...
He has to leave at the end of his period of leave.
If the leave expires, but it's open to a student to apply for further leave to remain, unlike a visitor. And if a student resides in the UK for 5 months, leaves the UK for a day or two, he will have a reasonable expectation to be allowed back to the United Kingdom on the same visa, because of the very nature of his leave to remain. But a visitor will not have that expectation.
The difficulty with this argument, I think, perhaps, is the guidance which is given by the Secretary of State, which talks about an expectation not just of coming back as a student, as you give, but an expectation of coming back in a different category.
Yes, but my Lord, if you look at the guidance, it makes the point, which of course I accept, that if a person leaves the United Kingdom, say with leave as a student, and applies a fresh for entry clearance as a spouse, then leave as a student would count. But what the guidance does not say is if a person had leave as a visitor.
No, it doesn't give that example. I agree.
No,
but it can't mean, if the example is meant to be right, it can't mean that you've got to ask, would you expect to have leave or reasonable expectation of being allowed to come back in that capacity? Because it's envisaging you might have permission to come back in another capacity.
Well, it's quite specific. I mean, it's the point I raised with you, Mr. Malik. It is quite specific that it envisages someone coming back in a different capacity, and the most it does is give one example.
Yes, but lady, if one takes that literally, then a person, anyone, can always have.
That's your main point.
Yes, that's the main point. Yes.
You say effectively, this must mean something, and furthermore, you say it doesn't make sense, really, to allow visitors to be able to count this towards their period. How do we exclude it? Well, it's obvious that Parliament meant, or the Secretary of State meant to exclude it. Where do we find it? Paragraph 3. Because you can't find it anywhere else.
Yes, you have my point. So can I just conclude my submissions by
Mr. Malik,
yes.
you take what time you need.
I'm grateful. I think I have made all the points that I could have realistically made in this case. But can I conclude by saying this, that Mlernshen has not, in my respective submission, identified a purpose behind this provision. So if the purpose that I have put forward is not the purpose behind this rule, then what is it? The court, of course, have heard submissions from both sides, tested the arguments, but in my respectful submission, there isn't any other purpose that one can give to this rule apart from the purpose that I have respectfully identified, and the court, in my respectful submission, should aim to give a construction to this provision that only not gives it some purpose, but is also workable in practice. So if, for example, the court says, and this is the point that my Lord Sir Patrick Elias had in mind, that, well, if the applicant had done something wrong, then, well, this provision may apply. If the court leaves the point there, in my respectful submission, that would leave the provision too open to be applied, in my respectful submission, in a way that is not consistent. So what I have proposed not only gives a meaning to this provision, but also confines it to a particular specific category. And in my respectful submission, that is another attraction for adopting this interpretation. So for these reasons, I respectfully submit that the requirement in this subparagraph is not met. There is no evidence before the court as to what expectation the appellant had when he was seeking to leave the United Kingdom. There isn't a witness statement, and the conclusion reached by the Secretary of State and the tribunal below, in my respectful submission, is correct. So unless I can assist the court, these are my submissions, and may I also apologize to the court for wasting the court's time by taking the point on Hawk. I do apologize, but I have made it clear that that's not the point that I pursue anymore.
Thank you.
We're very grateful. Thank you very much indeed, Mr. Manick. All right, well, the Secretary of State having abandoned the second ground, anything more you want to say on ground one?
I'm hesitant to mention this, but I think my learned friends, the foundation of his submissions are that if we look at page 201 of tab 1 on the authorities, which is paragraph 276A of the immigration rules, I think the submission being made to the court is that paragraph A is the conditions, or to establish what's considered to be not broken in terms of continuous residence. But then when you look at Roman numerals 1 to 5, it's an exception within the exception, in that everyone is considered to have left with valid leave and returned with valid leave. But if you look at the rule, I don't think that can be right, because if you look at Roman numeral 1, these are circumstances where you've been removed because you've been deported. If you're deported, it's because you've committed a criminal offense sentenced to over 12 months, and whatever leave you have is cancelled, and you're deported, or as in left the United Kingdom having been refused leave to enter or remain here. So that means you've made an application and you no longer have leave to remain. So it's not a circumstance where this is an exception within the exception. Further, I believe, if you look at Roman numeral 2, I think Lord Justice Elias asks for an example of where's the clear intention. And I think Lord Justice Smith mentioned it has to be evidence in writing. An example is given where you have to sign a disclaimer. But that's obviously, your leave has ended and you have to be removed at some point, and you want to be removed voluntarily. So you could sign a disclaimer. So I can't see this being an exception to where you have valid leave to remain before you leave the United Kingdom and have a lawful basis of return. Also, I think the court has pressed the respondent on this point as to what's the difference between a visitor and a student. And I think 3 reasons have been given in different ways. But in essence, the first is the visitor has to provide an intention to leave after a short visit to the United Kingdom. He must have a maximum of 6 months. And the example being given is if he leaves after 5 months and he tries to return, he would be stopped because there's a maximum of 6 months. So there's no reasonable expectation for him to return. The thing with that is that, well, what if he leaves after 3 months? I think if you have to approach the rule, it has to be consistent. The rule of itself can't only be applicable to visitors. Otherwise, it'll be specific to visitors. I think it's trying to incorporate visitors, but at no stage has the Secretary of State pointed out what other category is this rule applicable to. In terms of point 2, he's mentioned that visitor has to show the intention to leave the United Kingdom in order to be granted a visa. I do apologize, but when we look at it, the Secretary of State accepts if he had a student leave. Now, student leave in 2001 would be under paragraph 57. And there, he would have to show an intention to leave the United Kingdom in order to be granted a student visa. So I think the same is applicable. I do accept Tier 4. The present rules don't have that criteria. But previously, and I think my learned friend can confirm more, because he has more memory of the rules than me, but looking at it, you still had to provide evidence that you have intention to leave the United Kingdom on the completion of your studies. So it's very similar to the visitor rule. But I think over and over, the Secretary of State can't point to any reasonable difference between a visitor and a student, despite the examples given as to when the visitor leaves and returns as a spouse, or when the student leaves and returns as a spouse. Because the focus is not, I would say, whether or not you have lawful residence, is whether or not it's broken. Whether or not it's broken. I think that's the point they're trying to focus on. Because he left the United Kingdom and returned, it shouldn't count. But what if he didn't leave? Then it would. I think that has to be right. Because if they accept his lawful residence, if he didn't leave, then it would count. The focus for the Secretary of State is that because he's left, that means something's different. But looking at the policy guidance, he's left and returned with lawful residence. Returned with leave within the 6-month period. So there's no reason for it to be considered broken in that context. Unless I could add anything further. I think those are the points in rebuttal, really. Unless the court has any further questions.
No, but I'm going to make exactly the same point to you as I did to Mr. Malik. This is now the substantive appeal.
Yes.
So don't feel constrained by having to make any points only in rebuttal.
I think
You did cover a lot of ground.
Yeah, I think I did. I think the one thing that does trouble me is that the Secretary of State is actually putting on the appellant that he has to decide what the purpose of the rule is, and that we haven't provided the court with an explanation as to the purpose of the rule. And I don't think that's our job. I think, in essence, it's the Secretary of State to decide what the purpose of the rule is. Our view is that we have met that rule, and not rather than met, we haven't fallen foul of the rule. Because the rule is more in the negative, isn't it? You have to show there's no reasonable expectation. Now, the Secretary of State's only submission is that because our leave is temporary, that means automatically we have satisfied the criteria. And I think that can't be right. Unless I could add anything, I don't think there's nothing further to add.
Right. Well, thank you both very much indeed for the lucid and helpful submissions that have been made. You will be unsurprised to hear that the judgments are going to be reserved. They will be sent to you when they are ready. Any typographical errors can be dealt with. This is not the opportunity to make any further arguments. And the court will be looking to you to agree an order which can be submitted to the court. And if there are any issues about the order, then we'll take written submissions on it. But in the meantime, our thanks to you both.
Cool, guys. Finish the last thing now, and as I said before, there is a delay of 90 seconds. What you